Hello, everyone. Thank you for joining us today and welcome. My name is Deidre or Dee, either one you can call me, Omahen, and I'm a full-time realtor with Location Real Estate. I focus on holistic real estate, so I'm looking at indoor air quality, mold awareness, and healthy home principles. I also run a Facebook group called Mold Air Quality and Wellness Northeast Florida. And I started that. I'm on a mission to really help the community deal with these issues because they can definitely impact people's health and quality of life. So please spread the word about that Facebook group. And that's kind of what started me on this idea to interview Lance Renfro because his name comes up all the time on all the Knockatee Facebook groups as, who should I contact about this issue? So I'm really thrilled that he was willing to come talk with us today and that we can record it and share it with other people. Um, so anyway, this is Mike Renfro. He's a local attorney and he specializes in construction defect claims and failure to disclose cases in real estate. So Lance, yeah, thank you so much for joining us. And I just thought we could start off with finding out what got you interested in getting into this type of law, the construction defect law.
Yeah, Dee, thank you for having me. And it's kind of my pleasure to kind of introduce myself and let you know kind of what's what's going to be good for you as far as information with construction defects and how you can pursue a claim if you feel you have one. What got me interested in this, it was kind of a weird and long road, but it boils down to I grew up in the construction industry. I grew up in Oklahoma doing just pretty much every trade under the sun. In Oklahoma, you don't have to have a contractor's license to build a home. In fact, my dad has built every home that we've been in my whole life, and so that kind of so I've just always just been in construction. Granted, there was a long period of time I didn't like it, and I just want to get out of it. That led me into pursuing a legal career as a law enforcement officer, which drug me into law school. Just like how plans change through life, it kind of led me down into, do I want to do this kind of law? Or do I want to do that kind of law? And I found a law firm where they focus solely on construction issues, and the owner is a general contractor. And so I thought, wow, that's a perfect niche because I know the substance of law I'd be practicing. And so I got started with him. And I worked for him about 3.5 years, and just learned a lot under him, and realized this is kind of where I want to land my practice and start my own thing. And so about a year and a half ago, I started my own practice, and I live here in Knockatee, so that's probably a big cause why you see my name a lot. Is I started it and I work from home, so I'm here in Knockatee, and just kind of just all the Facebook groups kind of got a hold of my name, and so it kind of took off from there. But just really excited about being able to help the community and all the new homeowners navigate these issues that I'm seeing a lot with different various contractors and construction issues. So as far as how to identify a construction defect, the Florida law pertaining to this is codified in Florida Statute 558. It's defined in Florida Statute 558.002, which is legally defined as a deficiency in or a deficiency arising out of the design, specifications, surveying, planning, supervision, observations, or the construction itself, repairing, alteration, or remodeling of real property that result to any of four criteria. And these boil down to four different areas that you can kind of pursue a claim, which is defective material, products, or components that are used in the construction, violation of applicable codes, which encompasses local building codes as well as Florida building codes, failure of design or real property to meet applicable professional standards of care, as well as failure to construct the real property or the buildings on the real property in accordance with accepted trade standards for good and workmanlike construction. And that's a lot to take in, and I understand that. So I'd like to kind of break that down a little bit. How that pertains to you would be, you find, we'll take a roof leak, for example. You've been in your house for, we'll say a year and a half to 2 years, because generally your contractors give you this 1 year warranty. But then, a year and a half later, you see a brown spot on your ceiling. And then so you're like, what do? You contract your builder. They say, well, there's tough luck. we gave you a 1-year warranty. We're out of that warranty period, so you need to turn that into your insurance. Well, that's actually inaccurate, and they're just trying to evade liability on that issue because especially when it comes to roof leaks and stuff, it can get very dicey and very expensive for liability. So their first order of business is to see if they can kind of move past that liability issue. And so when you take something like that, when you contact somebody, generally you want to find out what's going on with this issue. Is it a roof leak? Is it coming from the transition from the roof to the wall? What's going on with this? And generally, if you call me, this is the first thing I would want to do is kind of get another licensed professional involved to kind of do the investigation, find out what we have as far as the investigation. They can kind of give us a report to tell us what the cause of the issue is and what it takes to repair it and the amount of money it takes to repair that. Now, if the contractor has denied that they're involved in this issue, what we would do legally is we would need to basically provide the contractor a statutory notice of the claim for the construction defect. And that too is under Florida Statute 558. And under Florida Statute 558.004, it states that you must provide the contractor notice of your claim with enough detail to kind of give them an idea of what your claim for the construction defect is and generally where it is in the home. Is it the roof system? Is it the mechanical system, being your HVAC system or something like that? And so, we would have to kind of understand what we're dealing with first before we issue that 558 letter. But then we would give them, under that statute, we would give them 30 days to allow them to schedule a I don't want to mistake 30 days to at least schedule an inspection that if they want to do so. And then after 45 days from the time they were served this notice, they must provide a response. And if they don't provide a response or they deny liability, after the 60 days from that notice, you are clear by statute to file a lawsuit against them for a claim of action. And that can be on multiple vehicles of liability. You can do it through, if you're the original buyer from the contractor, so you have a direct contract with them, you can file a lawsuit for a breach of contract that would get you to the claim for these construction defects. You can sue them in negligence if we find that there's some sort of duty that they breached, and we can connect that breach of that duty to the actual damages that you've incurred. And as far as that, you have these different criteria that are defined as a construction defect. And so you have the material, anything that was used, if it whether it be the shingles were defective or the actual the labor was defective as well, whether it be say the shingles. So say they overdrove the nails, they're overdriven, and it's puncturing the waterproofing membrane to the roof system, which is causing that. That would be under defective material, product, or labor. If there's, as far as violations of Florida Building Code, there's a whole nother statute in that under Florida Statute 558, or I'm sorry, 553. That kind of it's its own has its own details, and we'll go through that here in just a second. But also the failure to provide proper design and professional standards of care. That would be through design, or if the layout of the designs and plans was the actual cause, like they didn't provide a transition correctly, and because of that we have this leak in the roof, or leak, water intrusion, whatever. That would be a design flaw, or failure to construct or remodel the home in accordance with accepted trade standards. That would be your subcontractor and trades that are providing kind of a subpar work that you might be able to pursue a claim on against the contractor. Because ultimately, at the end of the day, the contractor is the license holder, and they hold the liability as that license holder, because these subcontractors were doing the work under the licensed contractor's supervision, or they should have.
Can I go back real quick to when you were talking about design of the roof?
Mm-hmm.
What about, like, I've been learning a lot in all these mold inspection classes that when you have a really complicated roof line, there's all
Mm-hmm.
these places where the water is literally just lands right along the wall. So it's like a design flaw by the architect. Like, have you ever seen anyone be able to sue the architect or the builder for that?
Yes. Ultimately, the first line, your first line of liability is the contractor. So the contractor generally would be the entity or the person to employ or contract with the architect or engineer to design this type of system. Or if you have your own architect or engineer that designed the plans and you bring in the contractor to follow these plans, then yeah, you would have a direct contract with the architect or engineer. But yeah, I've seen several instances to where they have these transitions that are pretty wild, and ultimately, if it can work by design and they can prove that, there's still probably if it works by design, then it shouldn't be leaking. So then you look, well, was it done negligently or not to workmanlike standards of the trades? Did they do the flashing up the wall correctly? Was it did they do their hips and valleys correctly to where they're rolling out their membranes and getting all the the felt paper and everything laid out correctly? What's going on there? Is it done? Is labor done incorrectly? Is it the material that was used is not right, or what's going on? So it could be design, but it also could be the labor or materials as well.
I forgot to mention too, for people that are joining us, if you want to ask him a question, you can raise your hand and I can unmute you. Although I think I had it set up to mute everyone and it didn't, so I think they can unmute themselves. But also, if you want me to ask a question for you, you can send it in the chat, and that way it can be anonymous.
And I know that we're wanting to kind of tailor this conversation to mold related issues, which if you do sustain mold related issues under construction defect theory, then you would need to you would also have a separate cause of action if there's any personal injury that's relative to that construction defect. If you have mold exposure to where you suffer from brain fog or sinus irritations and all the various things that you get, all the symptoms that you get from mold exposure, that would be a separate cause of action, separate from the actual construction defect itself. And so there's a few different ways that you can go about doing that, and it would all be in the same lawsuit. Well, first there would be, if there'd be a statute cause of action for the building code violation. If you can show that there was a building code violation, and that had caused personal injury, then you could pursue the personal injury damages relative to the Florida building code violation, which a building code violation is not itself a statutory cause of action without personal injury. Because as long as the contractor got the proper permits and passed all the inspections that the county mandated and got through all that, unless they knew or should have known that the building code violations existed, there wouldn't be any cause of action specifically for the Florida building code violations. Now, we can prove that, but to sustain that, there would have to be a material violation, and that's defined as so. Material violation is defined as a building code violation within a completed building, structure, facility that has resulted in or may reasonably result in physical harm to the person or significant damage to the building's performance or systems. And so we would have to show that there was a material violation and this personal injury. You can also sue under a negligence, which is a tort theory, which would provide that the contractor had a duty owed to you to perform its construction duties in a manner to where it would not subject you to personal injury, to sustaining these symptoms. And breach of duty, that would be, well, there's we can show that there's causation between their negligence, the duty that they gave you and the breach of that duty. And then we could show that by showing that, we've got, brown stains on the ceiling or, bubbling on the paint going down the walls, showing that there was water intrusion, as well as, if we could get a mold inspection done, and that would show us that there was mold existing in the home. And then you have doctors' notes or doctors' reports showing that you have been exposed to mold and you have symptoms of mold exposure. So we'd be able to sustain a case under negligence through that medium as well.
That's kind of leads into one of the first questions we got. It was a actual story. She said her home was built in 2022. The home builder knowingly used lumber that sat out in the rain. They have documentation pictures. This was a big one, the moldy lumber. So I'm curious what your thoughts are. She said she tried to address it during construction to the point where it escalated to the president of the company. He flat out refused to address it or remediate per our third-party inspector's instructions. Fast forward a couple years later, I'm having health issues related to mold and moisture issues in the home. We hired multiple inspectors, determined attic lumber needs remediation. The builder has ignored our attempts to communicate for a year. We have sought legal help to no avail and have paid $30K out of pocket so far to save our home because of the neglect during construction. Would this legal expert be able to advise on this matter? There are other homes in my neighborhood with the same issues. And this is all over Nocatee too, the moldy lumber.
Yeah, I actually handled an issue like that on. I don't know if you guys are familiar with the issue that they had in the Vista over at 20 Mile, but Pineapple Corporation basically bought out that entire sub neighborhood in Nocatee and was building, taking contracts, taking money from the homeowners because they actually had to purchase the land first, took that money and took the money for all the deposits for the homes, and then just kind of dropped off the map at various stages of construction. And one of my clients, they had a slab poured for nearly a year, and the trusses were delivered and just set on the dirt. And they were, same thing. They were set in the dirt, and I think it was about 4 months when we got involved. The trusses were there, and they were warped, just soggy, with just would not cure and dry out. And those are obviously, well beyond their structural integrity and use, especially as an engineered set of trusses for that home. And so that all had to be scrapped. And, that became, basically a portion of the damages. And this issue here that you presented, that sounds like, you've done the right thing so far as reaching out to the contractor and kind of escalating as far as you can to see if you can get somewhere with it. They're denying liability. But you've done your own research and you've done your own inspections, investigations to find out, yes, this is truly what's going on. Yeah, that sounds like it's ripe for a lawsuit at this point. But as I said earlier, generally what we do is, make sure that, we get not only this, it's important that once we want to establish a claim, we want to make sure that we're addressing everything in the home that we would subject a claim for construction defects to. Generally, what I would like to do is get a residential inspection, a full residential inspection of the home, and find out, is there any other systems that are defective? Are there any other latent issues that hadn't been discovered that we would have to, raise as a claim later? And that way we can kind of gather them all together and present them under one 558 notice of defects and submit all of them as to one lawsuit. It makes it cleaner. It helps financially to where you're not, having to go through this over and over and having multiple lawsuits. And so we get going in the beginning, do our homework up front, and then submit the claim for everything that we've discovered in the home thus far as one claim under 558, and then pursue the claim that way. Now, where we lie right now is that since you've already done your own research and investigations on this mold issue with the trusses, we would want to we want to take care of it. We want to get rid of the mold problem, but structurally, that would be the next question. If all your lumber set out in the weather for this long and it's created mold, is this still structurally sound? And so we would need to get an engineer involved and see if the fact that they sit out in the weather this long, are they still structurally sound and has the integrity of the wood that you would expect, to hold up your home. And so once we do that, we get all the data, we put it into the 558 notice and give it to them, see how they respond, and go from there. But yeah, that sounds like a really good claim that you have.
And that was one of the other questions someone had, is what's the statute of limitation? Because like, how far back can you go from a house that you own?
Yeah, that's an excellent question. So how I kind of start out is generally, the builders provide you, and what they kind of candy code it as something that they're providing you under their cost is a 1-year warranty. Well, that's a statutory obligation as a contractor. So don't be fooled by that. So the 1-year warranty is mandated by statute. And a lot of times they lean on that because it actually is pretty expensive for them to maintain these warranties through these big warranty providers. And they want to hold on to that and use that for as much value as they can. So they say, well, we give you a 1-year warranty, and outside that, sorry, we really can't help you. Well, that's actually untrue. The state of Florida has a statute called statute of repose. And what that is basically it's a flat 7 years from the time you get your certificate of occupation. You have 7 years to raise a claim for any defects, whether latent or patent. And so that gives you 7 years from the time that the house has received a certificate of occupation, whether you're closed on it directly or not. It's the certificate of occupation, and then moving forward, that's how you'd have 7 years. The statute of limitations for the discovery of any latent defects is 3 years. And so you have, if you discover, I have a fuse that keeps blowing, and you just kind of don't deal with it for 3 years. You could raise the claim within the first 7 years, but if it shows that, hey, you should have known about this from the get-go, that might be a defense that they can raise against the claim. Okay. Because of you had the ability to raise it. You should have known that this claim should have been right from the beginning, but you didn't raise it within the first years.
Okay. And this is another similar timeline thing. What about if you signed an NDA with a builder? Is that you can't go back and sue them forever if you already got money from them for an issue?
Yeah, so if you've already raised a claim and you've settled on other various issues with your contractor, you signed a settlement agreement or an NDA, a non-disclosure agreement, you would have to pay attention to the language of that specific document that you signed. Both of those are binding contracts. If they are signed and executed correctly, they are binding contracts. So you'd have to adhere to the specific language that it says. So I can't speak to exactly a yes or no, but it just depends on whether or not the NDA or the settlement agreement covers any and all future defects or issues pertaining to the residence, or is it the ones that you specifically litigated on that particular issue?
Okay. So, we also was talking to someone who's looking into buying a new home, and they were wondering, do you have tips on how to protect yourself? Because you have to sign the builder contract when you're buying construction. Just wanted to know if you had some tips to avoid, so you can come back and get help if they do have defects and all that.
One of the best ways, because the big name builders, they have very, very strong contracts that protect them. One thing that they really can't get around is your statutory, your legal right to have the home inspection at various levels. The inspections are worth a lot because it's an inspector, a licensed inspector that goes in and knows what to look for and find them. And if you guys need a name or anything, I know a lot of very detailed inspectors that can give you a very detailed report on what's going on with the build at various levels and stages of your build. As far as your contract, I would just suggest just read it. I know it's painstaking. There's so many pages, but I think they do that on purpose to where, even when I purchase a home, I can't stand, as a lawyer, I can't stand reading through all of it, but it is worth it to read it and make sure you understand what you're signing. That way, you're not signing away something that you don't realize you're signing away. Now, as far as a public policy issue, it is good to note that Florida public policy prohibits builders from using exculpatory or contractual clauses that absolve them from liability for personal injuries or anything caused by the neglect from their construction practices. So basically what that means is if you read through there and you see language that kind of if it says that you indemnify them from any personal injury or they're not responsible for any personal injury or anything like that from the construction practices, then that's an unenforceable clause. And it's things like that you want to make sure you're not signing into, and then you have to litigate and argue about later, because then you would have to argue to the judge that, well, it's against public policy, but then you're spending a lot of money on an attorney to basically argue that position for you in court. So the best way to protect yourself up front is read, ask questions, and if you don't understand what's going on, I would suggest reaching out to an attorney that that practices real estate and ask them questions before you get involved with it.
Yeah, that's great advice. One thing we haven't talked about, and I was excited that you said you've had success with this, but as a realtor, we're always told, oh, it's so hard to go back and sue a seller for not disclosing. And you said that you have had success. I was just kind of wanting to know if you want to chat about that real quick.
Yeah, I did. And I can get into some facts of that case. It's pretty mind blowing. But yeah, so in the state of Florida, you as buying a home that has previously been lived in, you're generally buying a home on what's known as is contractual basis. So sale for or residential agreement for sale and purchase real estate property would entail, usually it says an as is contract. But what that doesn't do is it doesn't get around the law that is established by a case under Johnson v. Davis. It's a 1985 case that basically establishes that even though you're purchasing residential property, the seller still has a duty to disclose any known defects, not defects, but any known issues that materially alter the value of that property. So what that means is if I own a home and I try to sell it to somebody, I know that the roof's leaking. I must disclose that, and its actual knowledge is the standard for a case such as that. And so, in order for you as the buyer to be successful in a case like that, you'd have to prove that the seller had actual knowledge of this defect. The case well, one of the cases I was successful on, we took this all the way to trial, and the defendant was an actual broker. She owned her own brokerage. She was licensed for over 20 years. And she herself decided to purchase a home and flip it and put it on the market for I think an overhead. She would have made an overhead profit of a little over 700,000. And in doing so, there was various issues not disclosed. One of the facts was that this property had sat vacant for over 18 years. And another one was, that, despite, the property looking clean and looking completely renovated, which was advertised on her website for this particular property, it was fully renovated. Everything has been upgraded and redone, and it's all new. Despite that, there was severe insect infestation all over different parts of the house. The windows were leaking, the roof was leaking, and lo and behold, about a week and a half after the plaintiffs purchased this property, they were going to host a New Year's Eve party at their home. And so they were getting ready. They were setting everything up in the dining room. And then they experienced raw sewage leaking down from the master bathroom above into their formal dining room. And just it created a huge mess, I'm sure you can understand. And so it ruined their whole plans for that party that they had planned. And it turned into a money pit situation. If anyone remembers the movie Money Pit with Tom Hanks back in the 1980s, it turned into that very quickly. And so one of the main issues was, not was this just a regular homeowner? Oh, I had the home and I didn't know. This was a licensed broker. So the standard of knowledge goes way up. And I'm sure you can understand. There's certain duties that you have under your license to a buyer. And so because of that, and because of just how many problems happened, and the fact that there was some text messages and emails that we found showing that she was trying to hire subs with her contractor. She was trying to hire subs that didn't care that there was no permits pulled. She wanted to make sure that she was hiring people that were as cheap as possible, and there was not a single permit pulled for all these renovations. So, and one of the renovations was they relocated a bunch of stuff in the master bathroom, which that was really faulty work, causing the raw sewage leak into the formal dining room down below. Anyway, so we were successful in getting that case through trial, and it was wild to think that someone could stand gaining $700,000 and trying to say, well, I didn't know anything about any of that is kind of wild to me. So
It is. Well,
yeah.
someone just asked a question in the chat. They said, if the discovery of mold is after 7 years from the CO date, then do we have recourse to pursue the builder?
After 7 years, you really don't. After that, any lawsuit that you would file, that's the first defense that they would raise, and they would be right on that. The statute of repose is a very uh, bright line rule that the courts cannot get past. They would not be able to overlook the fact that it was 7 years and 2 weeks. It's 7 years, and you didn't file the lawsuit in a timely fashion within that 7 years. The case is dismissed.
I just had a couple more questions that someone sent me. This one, I'm sure it's just variable, but they said, how long can litigation take? And how often are homeowners successful in recouping the costs they incurred from a lawsuit and paying for like attorney fees and fixing their home?
Well, as far as attorney's fees, I've seen a lot of contracts from the big builders that we have here in Nocatee. In fact, I have not seen one lately that calls for an attorney's fees provision, which means that the prevailing party of any lawsuit, which is taken all the way through trial or arbitration, all the way to final arbitration award, would be entitled to recover attorney's fees if they prevail. Now, so what that means is, as far as attorney's fees, it would be proceed at your own risk, and the attorney's fees would just be a part of doing business in pursuit of your damages. In doing that, plaintiff's attorneys and me especially, like I am very acutely aware of how much I would charge on a case in comparison to how much damages is viably you're able to recover. And so, if you have, say you have hail damage on your roof, and we're trying to recover roof damage through an insurance claim, we would expect to get a full roof repair. But if you have just a small leak in one portion of your roof, and the fix for the proper fix of that would be less than $5,000, that would be something that I would be cautious in getting myself involved with. Instead, I would just try to help you try to pursue that on your own. That way, you wouldn't incur a lot of attorney's fees in pursuing such a small amount of claim, because attorney's fees, that $5,000 would be eaten up pretty quickly.
Is that something where, like, if you're counting someone, do you have like just a smaller fee that they can pursue it themselves, like you said, or you just give them advice on the
Yeah,
free?
generally, so how I do things is I would start off with an initial consultation, usually by phone. If it's a larger amount of construction defects, or it's something I think I need to look at, I would want to do the initial consultation at home. I generally don't charge for initial consultations, and we would kind of establish the details. I would send me the contract and everything involved on your claim, so I can kind of get a feel for what we're doing and what we're talking about, and then we can kind of assess the situation and see how much is this case worth? How much can you pursue? Is this a $20,000 claim at max, or do we have $150,000 worth of stuff in the aggregate when we calculate all the various house systems that are involved in your construction defect claim? And so I tend to stay as far away from chasing bad money with good money, and in doing so, usually if it's a smaller case, I would like to kind of stay on the sidelines and see if here's what you do. AI is actually a really good tool, and AI, a little bit of how you would proceed in your claim, or how to draft a pro se complaint. Pro se just means by yourself. You're not represented by an attorney, and so get help with that, as well as if, hey, Lance, I had this complaint that the AI drafted, is this accurate? And little stuff like that, I would rather not charge. That way, the damage that you're able to recover are the damages amount that you would need to actually fix your problem, because ultimately, at the end of the day, that's the money you're seeking, is the money it takes to fix the problem that the contractor has posed to you.
Okay. I had one more question, and I think there's one in the chat. What do you see as like the common construction defect that you find in Nocatee? And then do you see any hope in like building practices changing in the future so they don't keep doing these defects?
What was the first part? I did kind of cut out a little bit.
Oh, what's the most common defect that you're finding in the new construction homes?
Mhm.
Or is there one?
Yeah, the most. It's pretty various at this point. In Nocatee, I know there has been a lot of HVAC issues. whether it doesn't cool the home, especially this last summer has been pretty brutal. There's been a lot of issues this summer and last about, hey, I have a 3-zone system that has been, or a 2 HVAC system, one for the lower level, one for the upper level, and they both are running full time and just not getting the house cooled to where we want it. Or on the other end, it's cooling the house, but we have mold issues and stuff like that. That has been probably maybe a little bit more than the rest. But I do see a lot of variance in the construction defects here in Nocte. A lot of flooring issues, foundational issues, and roof. There's been a lot of roof issues, but I think probably ultimately there's probably been more HVAC issues I've seen, and whether it be a unit that causes mold, which that would be usually it's a unit that's actually too big for the home. So you have energy calculations that you submit to the county as a contractor, and they are supposed to provide the exact calculations for, and it gives you the type of air condenser outside, as well as the type of and size of the air handler inside the home. And a lot of times these contractors, they get these air handlers in bulk, and they're too big for some of the homes, but they put them in anyway and say, oh, we upgraded your HVAC system, so you're going to get colder air, which is true. But the problem is it's called short cycling. And this is where you turn your thermostat down, and the HVAC unit is actually processing too much cold air to where it doesn't have the opportunity to dehumidify the air that's coming through it, to the point to where it's lowering your humidity, your atmospheric humidity, down to where it's comfortable, and that creates mold. Anything above about 55% in a home, you're going to start experiencing mold issues over time, because that's the kind of the threshold level for mold to grow. And so you're cooling your home, but you're ultimately not taking the humidity down to where it keeps the mold away.
Yeah, I think that's a huge issue. Is there an easy way for someone like a owner to double check to figure that out, or maybe just have like an, because I was trying to figure that out too. It's like you need a professional to do a manual J calculation, right? Just to see that the builder did it correctly.
So this is what a lot of the bigger builders don't want you to know, is the fact that your plans and everything that they submitted to the county for to build your home is public record. And so you can go to the building department and request the building documents, the original construction documents for your home. And in that, they can give you the plans and energy calculations and everything. So you can have that, and if you know a good HVAC guy, or have somebody come in and analyze that with you, and kind of, it is a little hard to understand kind of what they all mean without that education. But to know that, your air handler is too big, you can kind of see, okay, well, this is what the energy calcs call for, but they put in this size unit, so I can see that it's too big, or it's undersized maybe, and this is what's causing my problem. And then if you can see some evidence of that, then you can get a licensed HVAC inspector or engineer or something like that out to come check and verify that problem, and then you would have a construction defect issue.
That's great. Very helpful advice. Thank you. Okay, this is the last one, and we'll let you go. Um, so this is the same person that passed 7 years, and they said, can you comment on remediation or repairs being covered by insurance? They discovered the defects after the 7 years, so they can go after the defects cause mold.
As far as recourse for that, outside of pursuing the claim against the builder, you could turn it into a home insurance claim, but again, you might have exclusions in your and a lot of times you do, there's specific exclusions for the original construction of the home that they have in the policy, so you have to check your policy language to see if it's in there. But I mean, generally at the statute of repose kind of tailors the law around the concept that at some point the homeowner has to end up just taking that responsibility as the homeowner, saying, okay, well, now I have this problem. The law wouldn't allow general deterioration or maintenance issues to fall on the contractor, as it is a home that's owned by the person who bought it. So at some point the law would have to kind of flip sides and actually kind of set some safeguards for the contractor as well. So that it used to be 10 years, but was it 2001 or two, they changed the statute of repose from 10 years to 7 years. So it's been pretty hard to deal with that 3 year drop, but it is now just 7 years. And so at this point, there might just be just a, you just have to see what you can do to talk to some contractors and see if you can do it, by yourself.
Yeah. All right. Well, thank you so much for your time. I really appreciate you coming and chatting with us. And
No problem. And if there's if there's any lingering questions, I don't mind answering questions and stuff. My goal as far as doing what I do is to help people out. Just to, if you have questions, let me know. I can answer them. I don't try to make money off of people's problems. In fact, I try my level best to put all the money in your pocket to help you and to help solve your issues. So if you have any questions that you come up with in the future, feel free to email me. You can email me at lance@renfrofirm.com. I'm sure Dee can put that in the chat and make sure you guys have that. And just feel free to reach out if you have any questions or if there's anything you want to discuss with me further.
great. Yeah. Okay. Renfrolaw.com. I shared it. Perfect. Yeah. I appreciate the offer.
REN. Actually, it's REN.
Oh,
Yeah. Don't want to get that
I
one
can't
mixed.
talk and type at the same time.
Right.
Okay. That looked great.
All right.
Well, thanks again. And thanks for all you do for the community. And thanks for everyone who's on, and have a great rest of your day.